Are children of Italian citizens now considered second-class Italians? And will the 1948 case still work under the new Law 74? Today, I'll answer your real questions, and some of the answers may surprise you. If you want to stay updated on Italian citizenship cases like this, subscribe now and hit the bell so you don't miss next week's Q&A. Question number 1 from Liza. I was recognized as an Italian citizen in 2023 through a court case. At the time, I was told not to include my minor children in the petition because after the ruling they could simply be registered directly at the Comune. Now, after the new law, my children will be treated as second-class Italians, since they cannot transfer citizenship to their future children. Is this true, and can I do something about it? Answer. Unfortunately, yes, Liza. Under the new Law 74 2025, children in this situation are treated differently and cannot automatically pass citizenship to their descendants. The only possible solution now is to file a court petition on their behalf, arguing that this treatment is a form of discrimination. This is a serious constitutional issue, in my opinion, and it requires legal action to restore the few rights. Next, a question from YouTube about 1948 rule and the new law. The question number 2 from Ocean Blue. My great-grandfather and great-grandmother were born in Italy and came to Australia in 1902. They had my grandfather in 1910. My great-grandmother died in 1946 and never naturalized. My grandfather never renounced his Italian citizenship, so my mother should have been Italian at birth and me as well, because the line was never broken. But under the new law, it says parents and grandparents can be dual citizens. Will the 1948 case still work or not? So, your line looks unbroken, and under the previous rules, you would have had a very strong case. With the Law 74, however, there are new restrictions, especially on situations where parents or grandparents held dual citizenship. The 1948 case could still be valid in certain scenarios, but it depends on very specific details and dates. Even a small difference in timing or documentation can change everything. This is why each case must be reviewed carefully in court. Now, another crucial question about minors born in Italy versus abroad. The question number 3 from Mark. Would Italy-born minors be included in this positive ruling as well, or just minors who were born in another country to Italian parents? That's a very important distinction. The debate and the constitutional challenges mainly focus on foreign-born minors of Italian parents, because they are the ones who risk being treated as second-class Italians under the new law. Minors born in Italy already acquire citizenship automatically, so the discrimination arises above all for those born abroad. This is why the current litigation is so important, to restore equal rights for all children of Italian citizens, no matter where they were born. So now let's look at a case involving grandparents and naturalization. The question number 4 from Pasquale. Hello Pasquale, how are you? My grandmother and grandfather were both born in Italy and lived their whole life there. but my parents came to America and became US citizens when I was a child. Can I still go through my grandparents for citizenship? Yes, it's possible to apply through grandparents as long as the Italian citizenship was never interrupted by naturalization before the birth of the next person in the line. If they naturalized before your birth and before 1992, we could evaluate a court action. Before 1992, dual citizenship wasn't allowed, so many people lost it automatically without a real choice. As I always say, every case is different, so it's always best to get a personalized consultation. And finally, what if both parents naturalized before your birth? The question number 5 from Joe. I'm first generation born in the USA, but my parents naturalized before I was born. I had about a 2-year residency requirement if we don't qualify for US sanguinis. Is there any possible path for me and my sister? Uh, so I lost the question. So, if your parents naturalized before you were born, you do not qualify under the US sanguinis directly. But a court case may still be possible, especially if there are constitutional issues involved. The 2-year residency path applies only if you already have partial eligibility under the current law. It doesn't replace the need for a valid transmission of citizenship. In some situations, litigation has been the only way to restore your rights. If you have your own question, guys, please write in the comments. We'll answer in the next week's Q&A. Maybe some of you noted that usually I try to respond directly below your comments, but please, it would be great if you can write in the comments. We'll answer the next week Q&A. And if you want a personal review of your case, book a consultation through the link in the description. And remember, subscribe now and turn on the bell and don't miss next Q&A.